Hi, everybody. We have about 25 or so participants. Welcome to Pearl Cohen webinar that has to do with US government loans and in particular with the PPP, the Paycheck Protection Program. Before we start, a few words about Pearl Cohen. Pearl Cohen, as most of you know, is a global law firm with offices in the US, Israel, and the UK, and foreign desks in other jurisdictions. Our legacy business is IP, but in the last 20 years, we moved from an IP firm to a full service firm, covering all aspects of business law that tech companies need, and we're dealing with innovation-driven companies all over the world, in particular on the US-Israel cross-border axis. We are about 330 professionals worldwide, 200 attorneys, a lot of PhDs, including one of our speakers today, Dr. Oz Halabi. Just before I present the speaker, Dr. Oz Halabi and Guy Milhalter, I just want to know that we have a nice resource on our website related to COVID-19 updates, obviously not to medical ones, but to legal ones. Oz and Guy are partners in our New York office, which is closed now, so they're working from home, obviously. Oz is leading our tax practice in the US, which has to do both with domestic and international taxation. And Guy is a leading partner in our corporate group. Oz, please take the lead.
Oz, you're on mute.
I was on mute. Yep, sorry guys. So thank you so much, Zeev, and welcome, guys. We are now at 71 attendees, which is great. So good afternoon to those that are in the East Coast. Good morning to the West Coast, and good evening to those that joined us from Israel. As I've mentioned, this webinar will be focused on the part of the CARES Act that was enacted in March 27 by President Trump's administration. But it will not touch upon all the components of the CARES Act. It will be focused on the immediate financing that US businesses are eligible to. We'll speak about the eligibility, we'll speak about the process, et cetera, et cetera. The CARES Act initially was a $2 trillion, a little over $2 trillion support law enacted on March 27 in response to the COVID-19 pandemic. It includes immediate financing to companies, grants to companies, and a little tax deferral alternatives, some changes in the net operating losses used. So the idea behind the plan is to support companies as soon as possible, immediately with cash infusion, and to support companies in the long run, the next couple of years, in the long run, to overcome the economic situation that those companies will have to face after, after we go back to normal. Specifically, the Paycheck Protection Program is a $349 billion loan program established under the CARES Act for small businesses. As you all aware, about last week, about Thursday, the SBA, which is the Small Business Administration, announced that the $349 million are gone, are over. People applied for them. But this morning or last night, we saw that there is some negotiations of increasing this amount by another $300 or so billion to add it to the original Paycheck Protection program. And that's in general. This is why we think it's very important, because it's right around the corner, another budget. and also companies that already submitted their application or day before the SBA announced the exhaustion of the $349 billion should not be discouraged because those are still in the pipeline. So the SBA is not doesn't accept new applications, but those that are in the pipeline will be considered. So what is basically that program? So small business. What is the PPP was meant to provide some support to small business companies or small businesses operate in the U.S. And the definition for small business in the U.S. is a little different than in some other countries in the world. A small business in the U.S. is a company that employs 500 or fewer employees in the United States. Eligible businesses can borrow an amount that equals to 2.5 times their average monthly payroll, and the money can be spent. So once you calculated what amount you're eligible to receive, then you get that amount, the 2.5% times payroll, and then the way to exhaust or to use the money is to apply it against payroll costs, rent, utilities, and mortgage interest, and some other expenses, but these are the most important things that you want to consider. So there are 2 steps, right? One is 2.5 times your payroll. That's the eligibility amount or the amount that you will receive, and then this amount should be used against what we just said. So if you take a look at this very helpful slide, the loan count, it's the number of loans that were submitted to or applied is 1.6 million or 1.7 million loans. The amount approved was $342 billion, and the lender count is 5,000 banks or lending facilities within the U.S. The loan size, as you can see, most of the loan size are between $350 and $1 million. That's the most exact quarter of the loans. And you see, as you go higher up, you see that the amount of loans or the percentage of loans compared to the program is significantly reduced. And that's because, the loan amount is capped at either 2.5 times your payroll or $10 million. So, as we go up and more companies are leaning towards the over $5 million, you see that we have less and less companies because they don't qualify under the small business definition. I think that's a very important question. Is the PPP still available? And the answer the answer is no, but the real answer is yes, of course. No, because there is no more money left on the table. Yes, because there are significant negotiations to allocate more out of the $2.2 trillion from other stuff back to the PPP loans. Practitioners in the area working with the SBA or policymakers that we talk to believe that this amount will even grow larger than the next $300 billion because it really proved, or at least the idea is proven to be that of keeping employees. And we'll speak about it very little soon, but then later with the questions that we're going to address. This whole budget, this whole PPP intends to companies to keep their employees. Don't let them go, just keep them. And the reason is, or the way is that the government will be paying those employees compensation. So the company doesn't have to really concern, although they're not paying 100%, but in any event, the government will sponsor or pay significant part of the compensation in order for the company to keep the employee and not lay them off, because it will be much harder at the end of the process to for those who got laid off to get back to work. We spoke about the Wall Street Journal and applications, and I said applications that have already been submitted will continue to be processed on a first come first served basis until there's no more cash. The next one is the EDLP, the Economic Injury Disaster Loan Program. I want to have my partner Guy, who has extensive experience with that. You can, Guy, the mic is yours.
Sure. Great. So good afternoon, everyone. Good evening, wherever you happen to be in the world. So as Oz has given some of the general background on the Paycheck Protection Program, it's also important to keep in mind that there are a couple other programs that some businesses might be able to take advantage of here in the United States. The first one is the Economic Injury Disaster Loan Program. Under the EIDL, companies are able to obtain loans of up to $2 million at a very favorable interest rate and over a very long stretch of time. Now, this particular loan, unlike the PPP, does not have a loan forgiveness element to it. So for some companies, it might not be quite as enticing a program. Historically or traditionally, the EIDL was used where disasters had occurred. So for example, after Hurricane Katrina, the United States has designated Louisiana as a disaster zone, and then the SBA was able to obtain budget to give those favorable loans to businesses in Louisiana. Under the current situation, the U.S. government has essentially designated the entire United States and all of its territories as essentially a disaster zone and subject to eligibility for participation in the program. So if that's something that your business in the United States is in need of some cash infusion on favorable terms, it might be a program worth looking into. Additionally, under the CARES Act, they added an additional element to the EIDL, and that element is that of a grant that is given to businesses who that apply. Now, that grant is for $10,000 that can be obtained by companies that apply. And by the way, technically the grant can be given and be kept even if the company that applied did not actually end up obtaining the EIDL loan. So that's essentially $10,000 freebie to be used really for government for the great needs that the small business might have in order to survive. And that funding has also run out, similar to the PPP, but under the current negotiations that are ongoing in Washington, there are talks and plans to infuse another $50 to $60 billion into that program.
Which is related to the PPP or is on top of the PPP, Guy?
It's on top of the PPP. So these are two separate and unique programs. Now there's an interplay between them. So for example, if you get the $10,000 grant under the EIDL, when you seek loan forgiveness, the calculation, the $10,000 will essentially be deducted. So you will not be able to both get the full forgiveness of the loan you got under the PPP as well as the $10,000. In addition to the EIDL, the Federal Reserve of the United States, which is the central bank, has announced about approximately 12 days ago that they are also going to open up a new loan facility to enable small and medium-sized businesses to obtain loans. That program is still more up in the air. There are far less details about it. The Federal Reserve simply released a term sheet with the general terms of what they will do. And basically what they said is that they will allow businesses with up to 10,000 employees and up to $2.5 billion in annual revenues to participate. So it really expanded it for companies that are far beyond the definition of small business under the Small Business Administration definition. And just the basic loan terms that they released is that the loans that they will give will be for with a 4-year maturity, interest rates of between 2.5% and 4%, and the minimum loan amount will be $1 million. This program would probably be more appropriate for larger companies that did not necessarily qualify to obtain a loan under the PPP. So those are the three main programs that we'll be discussing today. Obviously, the main focus of our discussion will be the Paycheck Protection Program, because that program has had the most amount of money allocated to it, or will have. And also, this program enables companies to take advantage of a loan forgiveness element. So that program has been of greatest interest to many small businesses. So having said all of that, the way that we were thinking of going forward is we're going to have a Q&A session moderated by Zeev, and we're going to hit on some of the key questions and the key issues that have come up. And additionally, as some of you have already seen, you're able to submit questions through the Q&A option. So throughout the discussion, we'll try to also address these questions as much as we can if our answers don't hit those questions already. So with that, I'll pass it on to Zeev. Yes.
Sorry for jumping in. If we won't be able to answer any question, we will review them after the webinar, and we'll get back to people once with answers to their specific questions in case we didn't cover anything. So Oz, getting back to the PPP issue, what are actually the loan terms and this forgiveness, fairy tale forgiveness issue that everybody's speaking about?
Yeah, so that's a very good question to start with. So so initially, when a company applies, they apply for a loan, and the loan bears the following conditions. Well, it's a 1% interest rate and a 2-year term, which so you would need to return it 2 years after you got the loan, and there is a 6 months of deferral of of starting payments, although interest accrues during this 6 months. However, once you obtain the loan, about 2.5 or 3 months after the date the loan was granted, a company will have to prepare a report how it used the money. And if it used the money for payroll, rent, utilities, mortgage interest, etc., things that are described in the act, in the CARS, not the CARS Act, in the SBA regulations, then this amount will be forgiven. This amount will be converted from loan to a grant, tax-free grant. So basically, at the beginning you get a loan, but then it becomes grant. I can describe a little bit. There is one important condition for the loan to be converted into grant, and that is your payroll cost. The payroll cost should be at least 75% of the loan you received. And the period of time in which you have to use the money, to utilize the money, is 8 weeks from the day you got the loan, or until the end of June. So if within this 8-week period you exhausted 75% on payroll and the rest of rent, utility, mortgage, etc., this full amount will be discharged. You won't have to pay it back. Discharge including the interest. Now, people sometimes ask, okay, but what do I need to pay to the bank in order to process the loan? Is there any bank fees? So the answer is no, there are no bank fees. Well, there are bank fees, but the federal government is taking care of that. So the act puts exactly what are the fees that banks can charge, and this all is paid by the federal government, whether the loan is converted to a grant or not.
Oz, you've mentioned that 5,000 banks are involved in one of your earlier slides. Is there
Yes.
any particular bank? Do you recommend that people submit the loan through their normal banking relationship, or are there banks that specialize in this matter?
That's a very good question, and SBA recommends you to go directly through your bank simply because they know you. However, we're familiar with a few situations where applying for a different bank was even faster, and companies got their cash or got their funding pretty fast through not their own bank. So if you have good relationships with your bank, yes, you can apply through your bank. If you have relationships with a different bank, or if your advisors or your consuls, they have good relationships with other banks, you could definitely try that as well.
Guy, Oz and you mentioned this magic number of 500 people as defining a small business in the US. Are there any issues with this number? Restating the question, what is a small business other than 500 people?
Right. So under the CARES Act, the definition has been expanded. So in addition to the traditional definition of a small business concern, the Act has expanded the applicability of the program also to nonprofits, as well as to small businesses that have 500 employees or less. And in addition, it has included an alternative way to obtain eligibility for the program. So let's just take the 500 employees or less test. Under the CARES Act and its implementing regulations and the guidance, the rules have stated that to count the 500 employees, you count all of the employees that are US based, or those whose principal place of residence is in the United States. So that's something that's very important to keep in mind, is for the purpose of counting the number of employees, you count the number of employees in the US. And that was made very clear in the final rule, which stated that you're eligible for a PPP loan if you have 500 or fewer employees whose principal place of residence is in the United States. In addition, another way to be considered a small business that is eligible for the program is, even if you have more than 500 employees, you can still qualify if you meet a certain test called the Alternative Size Standards Test. And under that test, if your net worth, your tangible net worth, is no more than $15 million, and your income is no more than $5 million, then you can also qualify as a small business, and therefore be eligible for the PPP.
Oz, what about we deal with a lot of companies that are a group of companies, a parent and a subsidiary in the US, or a US parent and subsidiaries elsewhere. What about these type of companies, and what are the rules that apply to them?
Yeah, so this is very much related to the determination whether or not your company employs more than 500 employees. And there are a couple of tests in the rules of the SBA. So the way to calculate the 500 employees is either, as Guy mentioned, on a company basis, and then if you're VC backed, or if you have investors, or you have sister companies or affiliate companies, then there are 2 more or 3 more tests which basically get counted under the affiliation rules. The affiliation rules basically tell you that either of the three tests. One, if you have a shareholder, individual, and not individual as a person, but one shareholder, whether it's an individual or an entity, if you have one shareholder that has more than 50% ownership in your company, then you have to go and count every other company that this individual, this shareholder owns 50% or more, and count their US-based employees in order to determine whether you have 500 employees or not. So we basically allocate those employees of other companies to you in order to determine 500 or more. There is another test within the affiliation rules, and that's the test that we in our firm or the startup or the high-tech industry are mostly encounter, and that is the control test. Whether your investor owns 50% or more, it doesn't matter. If they own 10% or 20%, that's enough. As long as in the documents, in the Articles of Association or the Certificate of Incorporation of the Investor Right Agreement, if this single shareholder has any voting rights over the company for the number of quorum, for dividend distribution, for ESOP or employee stock option grant, executive compensation. If this person has a negative veto right, then this is considered to be control, and then you have to go and check all this person's portfolio and see whether there is any more affiliation rules, controlling other companies or ownership. And the third test is the management.
Can I jump right here, because a lot in the audience are VC backed.
Yep.
Most VC investments, there are certain veto rights. So can you focus on this aspect of VC backed companies, and do they need to now review the SPAs, and do they need the VC to waive these veto rights? How can you go about it?
Yeah, so all of the above. What in the industry standard on the SBA loans and the PPP in particular is for the council to review the investor right agreement, the article of incorporation, or the certificate of incorporation, or whatnot, the legal documents of the company, to see if anyone has veto rights or falls under the affiliation rules. And let's say that most of the VCs require some veto rights, some require broader veto rights, some require narrower. And there are a couple of ways to deal with it. We have few companies with a couple of VC backed, and that VC in particular, this VC just sent a letter to all their portfolio companies. We check the affiliation rules. We don't meet the 500 criteria, even if we take all the employees in our portfolio companies. So don't even come to us and ask for anything. We tell you, you don't have a problem with the 500 employees. That's very helpful, because your investor tells you that the other scenario is that, yes, your VC has some veto rights, and the SBA approved that if your VC waives their veto right, then you can qualify. The affiliation rules won't apply to you. We had several clients that was able to convince their VCs to forgo all their veto rights in order to participate in the PPP arrangement. Now, some of them waive specific veto rights just to make sure that we qualify under the affiliation rules. Others don't want to bother, and they say, and they give you a blank letter saying, or not a blank, more umbrella letter saying that if there is anything in our legal documents that provides us with veto rights that can interfere with your eligibility, we're letting it go. We're foregoing those rights. So whatever it is, it's off the table. And that's very helpful, because we see a lot of VCs that are trying to help their portfolio companies.
So before
I just want to add one, Zeev, I'll just add one more. Oh, go ahead.
No, please. You want to add something?
I was just going to add on top of what Oz said, one of the things that we've also encountered with the affiliation rule based on ownership and control is that occasionally, you think that the VCs have the veto rights that rise to the level of control, but then when you review the governing documents carefully, you realize that it's not actually control of an individual shareholder, which would implicate the affiliation rule, but rather it's a right of a class of investors. And in that case, the affiliation rule will not apply because not one individual VC or one individual investor actually has the veto rights that implicate the affiliation rule.
Thank you, Guy. I'd like to go to some questions that we got from the audience, but before that, I'd like to ask you both practically, what do you recommend? I'm the CEO of company X. What do I...
Yeah, that's being practical, right? So that's a very important question, and I think that's the problem with the SBA PPP regs is that there a little bit of ambiguity because this legislation passed within what, 3 days, 4 days from approval of the budget to drafting and to publishing it, and we're seeing constant clarifications issued by the SBA. So what we recommend our clients basically is before you apply, you need to understand what rules may apply to you and what rules you need to overcome. Affiliation rules is one thing. The second thing is economic uncertainty. These are the most important two things that a company needs to understand before they apply. And what we recommend our clients is basically to do have a call with us, understand where you may be at fault or not, and then the company CFO or CEO, whoever it is, should prepare a short memo to file explaining obviously we're helping our clients, but you need to explain the law or at least the program. You need to put together the two important issues that you had considered, what the result of your consideration, and you want to put it in file. Then we propose clients to go to their board and get approval to apply. Why are we doing this? Because we want to make sure that before you apply, you took all the steps that required, but for a prudent person to make sure that you're eligible to apply. Because although the SBA program or the PPP program does not require personal liability to the loans, it keeps the criminal liability for false applications or fraudulent applications rather. And we believe that if you do all what I just said before you apply, it will be very difficult to, even if you were wrong and you interpreted the affiliation rules wrongly, it will be very difficult to the government to come and say that you had some sort of criminal liability because you didn't have the intent at the beginning. You did everything that is possible before you applied in order to substantiate your eligibility. And companies should do that, should follow this.
Well, I think all is pretty much covered these points. I know that we're running out of time, so I'll let you move on.
Excellent. So I'm reviewing the chat and three first questions from the audience. One is, what about, I assume it's 1099, employees that are not employees but subcontractors, small companies having two or three employees in the US working from home and submitting invoices rather than being on a payroll. This is one question.
Yeah.
Second question has to do with family-owned businesses. Are there any limitations to family-owned businesses? And the third one is regarding the use of the money. We'll keep this one to the next round. So please relate to these two questions.
Yeah. So I'll, with regards to who can apply and if you can take into consideration independent contractors and 1099 workers, the answer, unfortunately, and we've seen it countless times in the past couple of weeks, is no. For the purpose of counting the number of employees, it has to be employees of the company and not 1099 contractors. The reason is because independent contractors are actually eligible to apply for a PPP loan on their own as sole proprietors or as independent contractors. So that's with regards to the first question. So the second question with regards to family-owned businesses, the answer is yes. Family-owned businesses that are not VC-backed are absolutely eligible to apply, assuming that all other factors are met. So one issue that you might see with a family-owned business is that one family could potentially own other side businesses or have essentially a one company in one industry and then one in another industry, and the affiliation rules based on management would apply. And so when we count the number of employees, as long as we don't reach 500 employees, then there's no eligibility problem and they should be able to apply.
Is family members that are employed by the family-owned business are counted normally, or is there a special rule there?
There's no, based on the actual language of the law and the regulations, there's no carve out for family members. So they're not treated any differently. So long as they're considered employees, they count towards the calculation.
Two other interesting questions. One has to do with the use of the money. Let's assume I'm using only 60% for payroll. What are the rules that apply regarding forgiveness and the terms? Because I think that's for you.
Yeah. So the SBA, the interpretation, or at least the SBA position is if you use less than 75%, that you're not eligible for grant. So if you use 74%, you're out of the grant route. So you better use 75%. And by the way, I just want to, the grant amount is always reduced, or not always. It will be reduced if you let employees go. So they take the starting situation, how many employees you had in the end, and if you let employees go, you lose some of the grant. So we had one company that had 30 employees, and they said, all right, we'll apply only for 20, and this will leave us 10 employees to let go. No, they can't. They can apply for one employee even, but if they terminate someone from 30 to 29, this will affect their amount forgiven. Two more points about the forgiveness. If you reduce your employee compensation by not more than 25%, that doesn't affect your eligibility for grant. One, and two, if you reduce employees' compensation, or let's say employee is making more than $100,000 a year, and the 2.5% of your payroll is capped at the $100,000 per employee per year. If you take an employee that makes 250 and reduce their comp to 100, that would not affect your grant amount either. So as long as you reduce not more than 25% to those making less than 100,000, or you reduce to those making more than 100,000 to more than 100,000, that doesn't affect your eligibility for grant. But payroll has to be at least 75%, not less.
So what about
and just to add
that? Sorry, Guy. I'll let you complete the answer first. Yeah. Go ahead.
Yeah, I just wanted to add one more thing with respect to the forgiveness. If you did have to let go of certain employees between February 15th and April 26th, but then by June 30th, you rehire them, then the calculation of the amount of forgiveness will not be affected, and you will still be able to obtain full forgiveness, and there won't be any deductions to that. So that's just something to keep in mind. I know it's kind of getting a little bit into the weeds, but it's important to know kind of, for your head count and for your business purposes, what you can and cannot do.
That's a very good point, and relates to the next question that we got from the audience, which is, what about those brave companies that say, a challenge is an opportunity and we'd like to open in the new branch or subsidiary or any other activity in the US now, in the next few weeks? Can we apply?
So the answer to that is no, because the business has to have been in existence already by the time that the program went into effect. And when you think about it, the reason being is the legislature wanted to avoid a situation where clever entrepreneurial people start opening up a bunch of businesses, hiring people, and then get a freebie for 2 months. It has to have been a company that was in existence.
Another interesting question from the audience is, what about those companies that own a lot of assets in the US, but not necessarily many employees? So in order to continue to operate, they need, potentially this loan, but not for payroll purposes per se. What should they do?
So under the PPP, the rules are quite rigid as far as calculating the maximum amount that you will be able to obtain. And that is based strictly on the number of employees that you have. So companies such as real estate companies that have very few employees or none at all will simply not be able to take advantage of the PPP program. Of course, they might have other avenues open to them, such as the EIDL, which we discussed earlier, as well as the Federal Reserve's program once that kicks into gear in the coming weeks.
Thank you, Guy. Oz, again, a few more questions regarding the practicalities. People are confused what to do.
Yeah.
And this is comes up in various questions, can you share useful links with us? What should we do next, etc.
Mm-hmm.
Is there, first, I understand, and please correct me if I'm wrong here, that there's no direct application for the PPP. You must go through a bank. Can you explain this procedure again? Because at least someone in the audience are confused regarding how to go about it.
Sure. First of all, we need to understand that the SBA has many different programs. One in particular related to the COVID-19, but there are some disaster loans, and it's a hefty 7A loans by the SBA is something that in the US is being used quite a lot. And in the PPP, they kind of changed again, because it's a 2-day long process to get the new law in, they kind of created a new PPP loan. In normal course, you have to apply through the SBA. The SBA approves it, and then the SBA decides to which bank to send your request. And so it's not even in your hands to do that. But that's disaster loans. That's something else. In the PPP, because of the amount of loans, because of the amount of money, because the urgency, and because how fast people applied, all applications go through the banks. There are about 5,000 or 5,000 and something loan providers in the U.S. and people can apply to whoever they want. They apply directly through that lending entity or lending facility. I know Bank of America has their own application form online. They're quite good. I know Chase has their own online application. They're not as good, but they're fine. Citibank has their own. Bank Leumi, the U.S. branch, has their own. So banks already have their own application. So if you go to the bank website, you just Google PPP and the name of the bank you want, you will get this application. We are so that's how you apply. The questions that maybe touch on the very issue that you raised now, Zeev, is okay, I applied, never heard back. What should I do? Should I apply back now that they're extending, or not extending? Should I apply? No, don't apply twice. Once you apply, it's in the US, you all know that in the US, the system works. You applied once, it's there. Nobody's ignoring it. If you apply twice, both applications will go out. So we need to wait to understand what will be the SBA's instructions when they increase the amount. By now, if you applied before the date the SBA said we're no longer accepting applications, your application is in the pipeline. So it either will be considered towards the $354 billion that granted 2 weeks ago, or it will be considered against the new application, the new amount. Either way, we will know very soon whether you need to reapply. We don't imagine that you will have to reapply if they just increase the amount. The question is, what happens if you get a no? Can you then apply again? We don't believe you can. I know people that have applied again, but you'll have to explain it over audit if you're in audit why you changed your mind and reapplied. It allows us enough time now. Well, it allows us a couple of days for companies to do what I just said before is to understand and document their process in applying. I wouldn't recommend applying before having this set of documents in your file before applying. If you already applied, you can do that as well. That's totally fine. If you haven't applied yet and you're considering applying, do that, because in a couple of days, they may open another set of loans.
You're referring to internal documentation supporting your thought process, supporting the loan, because the loan request itself is like a 2-3 page document as far as I know. Not very cool.
Yeah, but you're making about 14 or 15 representations that you're eligible and you have economic uncertainty, and you know, the CFO can decide to themselves after consulting with the CEO or who not, yes, we have less than 500. Our veto rights are not that important. We have economic uncertainty, but I would definitely recommend having that in file prior to applying.
Guy, we asked what happens with companies with a lot of assets and no employees or very little employees. What about the other situation where companies have a lot of employees and they must, you know, at least furlough some of the employees for a while? What is the rule regarding these companies?
So those companies that are heavy on the number of employees, and obviously we still need to keep in mind the 500 employee threshold, but let's assume that one company is eligible and has 490 employees. They could conceivably obtain a fairly large and substantial loan under the PPP. One thing, though, that could perhaps be to their disadvantage is if this is the kind of business that, okay, so it has a bunch of employees, but the customers have all gone away, or its facilities have shut down. In order to be eligible for the loan forgiveness, you must spend at least 75% of the cost on payroll within 8 weeks. So you will end up getting the loan, and you will be sustaining your employees, which is a great thing to do. But during those 8 weeks, you may not actually be able to open up your facilities or do what you need to do, yet you will still need to be spending that money if you want to get it back in the form of a loan forgiveness.
So we speak a lot about payroll. What is payroll, Oz? What is included in payroll? What is not included? Is 401k included? Can you elaborate a little bit?
Yeah. So the definition of payroll in the SBA program or the PPP program is payroll and the health benefits that you provided to your employee and state taxes and employer side Social Security. That's the definition, but payroll providers in the US are very good in providing the numbers exactly to the companies, number of employees, their compensation, what is included and what is not included. But so remember that the base compensation is limited to $100,000. On this, you add the health insurance, et cetera, or the health benefits. So companies were able to get a bit more than what is the 2.5 times, you know, the $100,000. So you add a little more components. It depends on what you're providing to your company. If I may, that's very related to it or similar to it. Some companies in the US, smaller companies, usually employ their employees through an employment professional services company. So for example, in the US, if you have a company of 3 employees, you can hire those employees through TriNet, for example. And the reason companies are doing that is because TriNet has 18,000 or 20,000 employees. They can get better health insurance rates or some other things that are going towards employees' benefits. The fact that you hired your employees through TriNet does not disqualify your entitlement to the PPP loan. So the fact that your employees are actually employees of TriNet, or not actually, practically employees of TriNet, for this PPP program, they're considered to be your employees. So you take those into account as well. We know a few companies that came to us last night and said, yeah, but most of my employees, I have 35 employees, they're all through TriNet, I'm not eligible. You are eligible. Some companies confuse the limitation amount, the $100,000, and they say employees that make over $100,000 doesn't even get into the calculation. That's incorrect either. You calculate all your employees working through TriNet, making $100,000 or $500,000 a year. For those that make 500, you limit the amount to $100,000. So you don't disqualify those that work through TriNet, and you don't disqualify those that make over $100,000.
This would sound an absurd question, but what about, you know, I have employees like, for example, sales rep. Sales reps often work on a base salary and then on, you know, bonuses, commissions, whatever. What is the rule regarding these additions and bonuses in general? Can I, in order to meet the 75%, can I decide to give a special bonus to employees?
Guy, you want to take it or I'll take it? It's a tough question.
I'm trying to think. I'm trying to think because the regulations really don't go into those details. They just say that 75% have to be paid, have to be spent on payroll costs. Technically, I suppose that could mean handing out commission payments to your sales force, but at the same time, so long as you continue to pay the rest of your employees, you know, because if you drop salaries below 25%, by 25% for those making less than $100,000 or more, then you will still have the forgiveness deducted. So you kind of have to play the math in a way that will help you avoid reducing wages and salaries of employees, while at the same time, if you want to pay the commissions, then you can most certainly do that.
Thank you, Guy. Guy, we are about to close this webinar, so please, if you'd like to add anything or to re-emphasize any point, please do. We are left with about 4 minutes to go.
Yeah,
go
ahead, Guy. No, you go ahead.
I just wanted to bring up one important topic that I think we may have touched on just briefly at some point, but I know that it's of great interest to many people, and that is the question of foreign ownership. And many people have asked, my business is 100% owned by a foreign company, you know, an Israeli company. Am I disqualified? So that's a question that has come up time and again. We have not seen anywhere in the CARES Act or in any of the implementing regulations or the guidance anywhere that states that companies that are foreign owned are disqualified from applying. And it makes sense because the point of the CARES Act is to protect American jobs. And so long as the money goes towards an entity that is here in the U.S. and has U.S.-based employees, and those employees are being helped by the grant, that's what matters. Now, there's still a requirement to provide information about the ownership, but just by the fact that you have to provide information about your ownership does not mean that that you're going to be disqualified.
Thank you, Guy. Oz, anything?
Yes. Before we're going to thank you all for participating and letting us kind of lay out the ideas. I encourage you, if you're willing to. I don't know. This webinar is going to be on our LinkedIn. If you want to share it with your network, because there is a lot of confusion over there, and we want to make sure that those that are entitled to receive the cash, those that are small companies, smaller companies, those that don't have backing up by investors with deep pockets, those that haven't got affected by the coronavirus, and we know of a company that gave back the money because they don't need it. We want to make sure that a lot of people understand and get, because your questions are very important. Your questions are great. And those are the questions that we have to deal with on a day-to-day basis. So sharing this will make a lot of service to others that weren't participating here. And I also encourage you to be in touch, because we have a lot of updates on the PPP, on the US law in general, related to this. So we'll be on top. We'll be publishing updates and information. So follow us or add us or join to our distribution list, et cetera, et cetera.
Thank you, Oz, and thank you everybody for participating. This was I've learned a lot, and I hope that the participants learned as well. And we'll see you in the next webinar, and please continue the dialogue. We are going to answer to the best of our ability any remaining or further questions. Thank you.